I'm Swamp Rose, and welcome back to my live stream. So today I'm continuing my podcast on the Idaho 4, or the case against Bryan Kohberger. And this is going to be a pretty short live stream. I'm just doing some case updates and something that I thought was really interesting, a subject which I thought was really interesting, which we might hear in the upcoming status conference that's coming up Thursday, which is if Bryan Kohberger is going to be allowed to be wear, if Bryan Kohberger can continue to wear his suit. So hello to the live chat, and thank you for showing up today. Thank you to my mods for being here. Nice to see you, Angel D, and Too Fast, Nini. All right, I'm going to get going. I'm going to read you two documents. I have one soundbite, and then I have an answer to our question. I also just wanted to define what a status conference is, just so we know exactly what you're looking to expect on Thursday. Sorry if I'm like mincing my words. It's been a long day. All right, so let me read this document to you to start out with. So this is the order for the hearing that we're going to be seeing coming up Thursday, and it's at 2 p.m. And so here on my channel, that's going to be closer to 5 p.m. Eastern Standard Time. And so it's just, all this says is notice given by the above entitled case is set for status conference on Thursday, September 26th. And there's going to be a new channel that we're streaming this onto. So I'm going to link that in the description and the comments below so that you guys can easily have access to that. Or if you want, I'm also going to be covering the hearing live, and you can come see it on my channel. But what I wanted to do was play you a soundbite to kind of segue into this. So at these status conferences, actually, I should probably read you the definition of a status conference really quickly, just to make sure anyone who's watching who doesn't know knows exactly what we're talking about. Oh God, am I muted? No, okay. Okay, so a status conference, let me just read this to you. I'm not going to play the whole video that's right here, but this was a good definition. What is a status conference in a criminal court? In the bustling world of criminal court proceedings, you may have heard the term status conference, but what exactly does this mean? Let me unravel some of the legal jargon together. A status conference is also known as a pretrial conference. It is a meeting held before a trial begins. It is a formal gathering involving the judge, the prosecution, and the defense. The purpose is to discuss the progress of the case. It's an opportunity to resolve any issues that might hinder the smooth running of the trial. During the status conference, the parties may discuss the evidence, legal issues, and even potential plea bargains. It's a chance to ensure that everyone is on the same page before the trial commences. Remember, each case is unique, and the number of status conferences can vary. In some cases may require several, while others need one. And oh, hey, Robert. Hey, Sirius. Nice to see you. Oh, Twiz is here? Yay. So I have a feeling that we're going to hear, we're going to hear what the grievances are. Anne is probably going to bring up what she thinks is going to be delaying the trial. And what I thought would be an interesting thing to kind of revisit is a soundbite we heard right after the change of venue was announced. And this is a soundbite that was with the Gonzalez family. And I think it's worth listening to where they speak on this, because they talk about what changes we might see if the venue gets changed, or what changes that they would like to see if the venue got changed.
You said, you got to be more aggressive. You guys have to be more aggressive. And they push back at us. And here we are 2 months away from 2 years, and they're resetting. So we were right. We told them they needed to be a little more aggressive, maybe a lot more aggressive, somewhere in the middle. And, here we are today, and we were right. But we can course correct. We can get this fixed. We can get the right guy in the right chair, and we can go from there.
This isn't the end. This isn't the end of the road. This is not over. This isn't a, because I take it to heart, like that's a win for them, and it's like tick for tack. But other people in the family have different mentality than that. And they say, Mom, you gotta look at the bigger picture. You can't, it's not tick for tack. It's not tick for tack.
So you can imagine, Ashley, how difficult it's been for them and for the other victims' family members to think that now there's going to be a whole new venue. They don't know where it is. And on top of that, there's going to be a whole new judge.
Okay, Jen, I have this other question because last week we were talking about 13 filings that his defense attorneys put forth to Judge John Judge, who's still presumably hanging on until a new judge is appointed. But what do we know about those filings? They want the death penalty off the table, and they suggested all sorts of things, from it's unconstitutional to, the cruel and unusual punishment, et cetera. Where does that stand?
Well, we don't really know if Judge is hanging on. I've been trying to figure it out. I was talking to Shannon Gray, the Gonzalez's attorney. There's a thought here, and it could happen that he's just done already, that the Supreme Court's going to decide, hopefully quickly, who the new judge will be, where this will move to, and the new judge will take over right away. And you mentioned this argument right now over the death penalty. The defense is trying to get it thrown out. Prosecution has to weigh in. There is a hearing set for November on that, Ashley, which is a big hearing. We all assumed that it was going to be in Moscow, Idaho. Likely not going to be in Moscow anymore, not going to be in front of Judge. So is this going to delay things? Will that hearing still happen in November? Where will the hearing be? I mean, you can understand the frustration with the families not really knowing.
Yeah. I also heard Mrs. Gonzalez say something about they're going to get some new help in the chair. And I'm not sure if she was referring to whatever new county comes along is going to help out with prosecution. I don't assume that's the case. I assume these prosecutors will move to a different county, period.
Yeah, it's going to be the same prosecution. Okay, it's the Latah County prosecutors, and then they've got the help of the state attorney general's office. What she's talking about in the chair, when she says we're going to get someone new in the chair, she's talking about the judge.
Thanks for watching. Go to joinnn.com to find News Nation on your screen. And don't forget to
All right. So, I mean, I don't know if that was the exact soundbite that I wanted to show you, but you get the gist. These are some of the questions that we're wondering. And this is going to be our first time seeing the court operate like this. Just a couple of observations before I read you the next document. First and foremost, from what I've seen, I think that this court is trying to demonstrate in their actions that they're efficient and that they move quickly, because we saw them, we just saw them react and file paperwork quickly and schedule this hearing. So I have hope because of the larger venue. They have like 40 different courtrooms. They also talked about, the judge talked about, he talked about other instances where he actually had other judges within his courthouse cancel cases to help with scheduling issues. So it looks like he utilizes his schedule. Another thing is, before I read you the document regarding whether Bryan Kohberger is going to be able to wear his suit in court, I will say, as an example that we might have seen come out of this courtroom, was the Daybell trial. We saw that in both defendants in that case were allowed to wear their court clothes until the point they were convicted. And then at that point, they were put in shackles and in their orange suits. And it's not necessarily, the answer to the questions is not necessarily a right that somebody has. Although if you're trying to have a fair trial, people can argue in appeal that was a reason why a jury might have been influenced. So judges will often allow that. It's something that the defense has to motion for. And let me show you this document, because Ann Taylor filed something for it on the 20th. And if I'm getting this wrong, just remember, I don't have a legal background and I'm just explaining these documents the best I can. And actually, I'm just going to take a moment to tell you that everything I say in this video is just simply speculation, in my opinion. And I just encourage you to do your own research to form your own opinions. And Oh, wait, hold on a second. Heather's here. Thank you for being here. And Heather says, there's no way they didn't intend on having this trial moved. The fam telling Enron they contacted Laytar residents absolutely would have caused the judge to move the trial, especially since JJ paused. Yeah, we were all just like, what did you just say? I have the clip actually, because I was going to play it. I was planning on doing a longer live stream before, but yeah. And I think a lot of people in the chat would agree with you. Tara says, actually, in the motion, Ann argues why he's entitled. Let's read it. Let's read it together. Okay. It's not a long document, but I do want to read the whole thing. In the District Court, Second Judicial District of the State of Idaho, in and for the County of Layton, motion for defendant to wear street clothing to all public hearings. Come now, Bryan Kohberger, and sorry, let me start. Come now, Bryan Kohberger, by and through his attorneys of record, and hereby request that the court provide an order for Mr. Kohberger to attend all public hearings in street clothing. This motion is based on the 5th, 6th, 8th, and 14th Amendments of the United States Constitution. The article is 1 and 1, 6, 7, and 13 of Idaho Constitution. This request is owing to the public nature of the case and the vast dissemination of the images of Mr. Kohberger. In the United States Supreme Court in Estelle Corrections Director versus William 425 U.S. 501, 1976, recognizes that causing a person to appear in front of his or her jury in jail clothing would impact the presumption of innocence. Mr. Kohberger respectfully requests that all public hearings be considered prejudicial similarly. In the years that have passed since the Estelle case was decided, technology has changed public access to the accused. The public has the ability to attend the public hearings through a live streamed hearings. Potential jurors are exposed to every hearing. Mr. Kohberger, having been recently granted a change of venue due to the ongoing vast and prejudicial pretrial publicity, recognizes that the continued media coverage may impact his right to a fair and impartial jury. As such, avoiding coverage in the jail clothing is one thing that could reduce prejudice. During the short time between Mr. Kohberger's transport to Ida County and the drafting of this motion, Mr. Kohberger's defense team is aware that at least 900 media stories, many of which have focused on Mr. Kohberger's recent booking photo depicting facial hair, as well as placed in the record at the hearing and the venue change, expert testimony is that the public interest will not wane. This testimony continues to be accurate, given the intense nature of the media coverage in the immediate past 5 days. Much of the media coverage and social media posts focus on Mr. Kohberger's appearance. Authorizing Mr. Kohberger to wear street clothing to any public hearing is one way to reduce potential prejudice. Counsel for Mr. Kohberger has had the opportunity to speak with Ada County Sheriff to command staff about street clothing for hearings, and they are able to accommodate this request if so ordered by the court. All right, so I really want to turn it to the chat. What do you guys think? I mean, I think that all of us would feel that prejudice would be involved seeing somebody in their jail clothing. I think just if you watch this trial and you've listened to the experts talk about how images of like just using certain words in a title and then exposing a defendant's image can cause the defendant to have negative or can cause a juror to have negative impressions when they get onto that chair. So I do think that this is a valid argument. I don't know how you could argue against it, but if I'm wrong, if you disagree with my take on this, I'd love to hear your opinions in the live chat or in the comments below. And while you're here, if you've made it this far through this live stream, if you could please hit that like button, I'd really appreciate it. As a creator, every time you hit that like button, it helps me because it puts this live stream in front of another person. And I would hope that you would consider subscribing to my channel. I put out new content daily, including videos, shorts, live streams, community posts, and a lot more. I also have a members feature where I feature a lot of exclusive content. And lastly, if you could please hit that notification bell if you're a subscriber, because we go live all the time, and I would hate for you to miss out on the live chat and the conversation or being part of the replay crew, because oftentimes I make these live streams private or members only afterwards. So let me know what you think in the comments, and peace be your journey today. Thank you, live chat. Thank you, mods.